Quorum. The first item is to elect a chairman for this meeting, please. Can I have nominations?
Move Graham Nicol.
Councillor Nicol, are you happy to accept the chair?
Thank you, members. I'd like to remind everyone present this meeting will be recorded, and the recording will subsequently be available for public listening, if they can hear it. Paula.
There are no apologies.
Any declarations of interest, members? No. Okay. We'll go on with the business. Land south of Holmhead Farm, Moniaive, refusal of planning permission in principle for erection of 1.5-storey dwelling house, formation of access and installation of septic tank and soakaway. David, have you got any slides or anything to show us?
Yes, Chair. We can go into those. These are the same slides that you have from page 91 in your agenda, but just to run through them. This is looking southwest towards the site, and basically if you see more or less in the centre, just maybe to the left of centre on that slide, there's a area where the pointer is just now. That's the proposed site of the house. And panning across from that one, you can actually see Holmhead Farm itself sitting in there. This is looking down from the A702 down towards the site. So the proposed house would be in the area which has been excavated there. A view from the A702 itself with the area which the improved access would be formed. The existing access obviously is sitting in there. And the access down to the house from the 702 would go through this land here and then basically snake down the slope to where the house would sit. And at the top of the hill, which if you go back to the first photo in your agenda, you can actually see where the corral is. This is the corral. There is a static caravan, which you'll note from the appointed officer's report is currently unauthorised. And that's where the applicant currently lives. Thank you, Chair.
Okay, Paula.
The Chair will take the committee through the papers that are set out in the agenda. Following that, it falls to members to determine whether you have sufficient information to determine the review today or if you require other information. The options available to local review body are that you can determine you have sufficient information, proceed to consider the application. To request further information, which can be in the form of written submissions, you must specify what information you require and who you require it from. You can resolve to hold a hearing, again specifying who you would wish to speak and on what matters, or you can resolve to hold a site visit. If the local review body determines that you have sufficient information and that no further procedure is required, you have full powers to uphold, reverse or vary a determination. The decision notice for any decision made will include a statement of the terms in which the planning authority has decided the case. A planning advisor is present for this item. It is confirmed that he did not have any involvement in the case and was not the case officer or appointed officer for the application. He is here purely to provide independent advice. And I ask the Chair to take the papers, and the first matter will be to determine if you have sufficient information to consider this matter today.
Okay. Do you think we have enough information in front of us to determine this today? Councillor Gilroy?
I would suggest that we do.
I certainly agree with that.
Section 1, notice of review, dated the 24th of October. Is there anything in that that people wish to ask questions about or comment on? And that's from pages 11 to 38. Pages 11 to 38. Councillor Crothers.
Just in regards to, I thought we'd have picked up on it later on in the debate as we got going. At what point, just to, so I'm absolutely clear on the process we're undertaking here, there's lots of, throughout the whole report, not just in this, but there's bits of clarity I would like on it in regards to, in particular, how planning policy is applied in a consistent manner. So I'd just like to, is this the time to pick up on it? Should I pick up on it once we've kind of been through the whole lot to make sure that we're happy with what's in front of us, or what kind of process are we taking here?
I'm happy to take questions as you go through it. It's probably more appropriate as you go through to raise each individual point.
So have you anything in this first question, the first point to Councillor Crothers?
Well, I suppose it's going back to their point in Section 8. Section 7, I agree entirely, the review of the procedure, they're asking in point 1 that they wish it to be determined with what's in front of us today. I would agree with what's been said already. But under Section 8, statement setting out the reasons for the review, they're saying quite clearly that there's a labour need there, and there's an argument goes through the whole report. That labour need, is it correct? Does it stand up on its own merits, or does it not? And I'd like to go at some planning advice in regards to that. So it's not just here; it goes right through. What should the planning authority take in regard when it comes to what's being put in front of us? Because it comes back. The appellant has or the person asking for the review has the last word on this through the report. And they state quite clearly, if you actually formulate this in the way that the council are saying they should formulate it, it comes to just short of 2 labour units. But that's not how the previous decision has been made.
In essence, that's the nub of this review, that the information was given at a certain time, advice was given as to what would be required, and the appointed officer wasn't satisfied that the information that had been submitted at the time they determined it was in the correct format for them to do that. What appointed officers normally look for is a Scottish Agricultural College report which sets out the various aspects of agricultural use. There is an issue as to the definition of agriculture and whether various things can actually come in, and I suspect we'll come onto that later. But the nub of this matter is that the appointed officer, at the time they determined it, did not feel that they had the appropriate information to allow them to determine it in a positive manner. The applicant obviously feels differently to that, and that's why it's before you today. But one of the things which you've got in Section 8 on page 13 is the issue of the Animal Welfare Act, which is one of their key arguments, that they feel planning permission should be granted to allow them to enable the Animal Welfare Act to be implemented properly. The appointed officer's view as well is that correct? Is that sufficient for a justification? Are there not other methods in which that could be done? So that there's a divergence of opinion on this one.
Okay.
Okay, I'll come back to that as we go through the report, because really it's the last, probably the last section of it is more relevant with the arguments made.
Okay, is there anything in Section 1 then that members want to ask questions about, or that's up to page 38? 39 maybe? 38. I just noticed that in page 19 there is a letter from A&C Cameron, and it's not been signed. Is that of any significance?
Probably not, because even if it was, the officers would have to have got that signature redacted out anyway.
Yeah, I'm not disputing that. What I'm saying is is it official because it's not signed? I mean, I would appreciate it would be redacted, but there's no evidence that that actually came from ANC Carbon.
It certainly was submitted by the agent. I don't think there's any ambiguity over that.
Anything else, members? Okay, section 2, report on handling. Takes us up to page 49. Councillor Crothers.
I'm not going to be specific in this, apart from one point, because when I was reading through it, you're gaining facts how the previous decision was made. But when I got to, a couple of times I felt uncomfortable with some of the terminology, but when I got to 4.5, I felt really uncomfortable. And for the record, I'd like to distance myself from the remarks that were made within that paragraph as a member of the council. Absolutely. Because I can't get because of the wire stuck. So I'm just saying that, and as I read through the report of handling, that a couple of times I felt a wee bit uneasy, but when I got to paragraph 4.5 in particular, I felt quite uncomfortable when I read that, and I'd like to, for the record, distance myself from the remarks made.
Okay, noted. Anything else, members? Okay. Sorry, Councillor.
Just on that, I think further on, I think one of the things that the applicant does say that there was inappropriate comments. I can't quite remember where it was. 59, I think, page 59, I think it was. And I just would like advice from the planning officer whether that is actually, whether he agrees with that or not. I think it was page 59 of 94, section 2B, and also page 60, section D at the very DE, where the word appropriate has been used in reference to comments by the planning officer, appointed officer. Can we just have a...
Well, in my role as planning advisor, I'm actually neutral on that. Basically, that's the opinion of the case officer, which appears to have been signed off by the appointed officer. That's their opinion. In the same way, in page 59, that's the opinion of the applicant's agent. And as I say, I'm actually, from today's perspective, I'm neutral on those comments.
Just to follow up on that, is it appropriate for an officer to have such opinions in a report like this?
The officers are entitled to state what is their bona fide professional opinion, and that's what they should be doing. If there was inappropriate language used, then that's a different matter. But having read through this, it's clearly an opinion. Whether it's considered to be an inappropriate terms of language is a matter of personal interpretation.
Councillor Blake and then Councillor Coast.
I would tend to agree that I don't think it is appropriate language. I think it's unduly harsh. It's making a real accusation. I don't think this is appropriate language.
Councillor Coast.
Yeah, I have to agree with what the previous speakers have said. It's usually the word contrived, actually. You know, if the planner has said, I believe there may have been something happening. It's the fact he's accusing. I mean, he's not legally qualified in terms of making that type of accusation, because what he's talking about is how the ownership of the land changed. Now, sure, the ownership of the land has got nothing to do with the planner. You can apply for planning permission whether you own land or not. So I don't think that, if it was a council lawyer said, in his opinion, he thought the way the land was transferred and it was contrived, I would accept that. But I don't think that's for a planner to make comment on. It doesn't help the planner's case, because all he's doing is antagonising the applicant and the applicant's agent as well.
Maybe in there because he was antagonised. We don't know how it's arrived there. But, I mean, basically we're here to decide if the appeal is for a house on this site, and we're here to decide if that is appropriate to have that house on this site. So I'll...
Would it be appropriate for us to say, we'll make this decision, but we're not going to take 4 or 5 into consideration? Would that be an appropriate way to to proceed, and that protects our back if there was any ongoing problem coming from the applicant.
Chairman, I mean, that's the reason I made my point quite clear. I removed myself completely from the remarks throughout there, in particular 4.5, in case there is any legal action thereafter.
I mean, obviously the point is the case officer made that comment in the report. It's a matter of public record. It's on the web. Whether or not you agree with that comment is entirely up to yourselves. I mean, for the record, I think what he was trying to say is if you look at the nature of the application site, it is a very long, linear, small area of land. And I suspect the background to this is that they're considering that this is a method to try and circumvent planning policy, to actually create a not particularly viable farm unit and therefore try and get a house upon it using the justification. That, I think, is the point he was trying to say when it was contrived. But obviously the fact of the matter is the land has been sold. The planning application has come forward on the basis of that land that is there. And it's really effectively for yourselves as the LRB to determine whether or not there is an essential need for a house on that land that exists. And whether or not it's contrived, I don't think is necessarily for yourselves to get too worried about. That was the officer's opinion. If you disagree with that, that's entirely fine.
Anything else in section 2? We want to section 3, observations of the appointed officer on the applicant's notice of review. This was signed by Robert Duncan, Area Planning Manager. Councillor Crothers.
Thanks, Chairman. I think, for the record, this has been well written, I think. I like the way this is worded, but it comes through the same theme again. It's in regards to the argument. I'll maybe come back in the very last part of or the next stage, I should say, not the very last, but the next stage. The argument comes again from the appointed officer, which substantiates the full-time equivalent or the labour force. Is it one? Is it under one? Is it just short of 2, 1 3/4? So I'll come back to that point at the next. But it's there again within his. He's picked up, and it took a similar view to the case officer, but the argument comes next, and I think that's where I want to get clarity from David at that point.
Any other members? No. Item section 4, comments of the applicant's agents on observations of the appointed officer. David?
This is perhaps the most awkward part because, as you'll be aware, when you submit a notice of review, you're supposed to submit everything you wish to be considered at that stage. And if you're introducing new matters, then that's supposed to be flagged up on the application form. So if you note, just referring you back to page 13, 9 new matters, it's blank. There's nothing been mentioned. But on page 59, you've actually got a completely new calculation in terms of the standard labour requirement. Probably the most critical issue for you to determine today is whether or not you're actually going to accept that. Basically, that information wasn't before the appointed officer. There are 2 elements of that which, coming to this afresh, I've looked at, and I would query. The appointed officer gets no opportunity through this LRB process to comment on that. So it's really just whether or not you are willing to accept that as new material today. And if so, how much weight do you actually wish to give to it? If you want clarification on the concerns that I would have about this, then I'm quite happy to do that.
Councillor Crothers.
That was my very point. I think David's absolutely right in what he's saying. So that's what I was saying. I thought this is new matters. It's been introduced. It wasn't in front of the original case officer, and I'd very much appreciate and value any information or advice that David can give us in regards to how much weight we should give towards what's been put in front of us. I think the fact is, it is in front of us, it's in the report, it's there. We must accept it as new matters, but like David says, I think that's for the committee to determine.
You're basically under no obligation to accept something new that comes in. That is, as I say, that's the role of the LRB to actually say, okay, well, we've got this. That wasn't before the appointed officer. might a different decision have been reached if that information was available? The two things which, just reading through it last night, I came up with was that if you look back, it makes it clear that they've got 20 cows, they had 20 calves, which were then sold. So during the year, there would, at certain points, have been 40, but their actual number of beef cattle is, if you like, the baseline is 20 rather than 40. And the critical one is the fact that the horses are being counted in here. The definition of agriculture, given under Section 277 of the Planning Act, is including creatures which are kept for their production of food, wool, skins, or fur, or for the purpose of its use in the farming of the land. So horses are not regarded as agriculture in planning terms. It's a specific horticulture. So whilst that is clearly part of the business plan, if you like, you couldn't reasonably count horses as agriculture under the planning definition. And if you were to remove that figure, then you come up with a completely different set of figures. For example, if you're keeping it at 40 cattle, I make that to be 564.5 hours per annum, or a 0.29 labour unit. If you take it down to 20 cattle, that comes at 325.5 hours per annum, or 0.17 labour units. Now, obviously, the horses are on site, the horses are forming part of it, but they are not in planning terms regarded as agriculture. So that immediately flags up to me that there's been no opportunity for the appointed officer to look at that information and come to a balanced planning recommendation. It's effectively just come in at the last possible moment for the applicant's agents to make a comment, and it's got landed into you as this sort of last-minute thing which you've got to assess. So I think that, being honest, I think that puts you in an invidious position. You're suddenly given this new material without the ability to actually properly scrutinise it. And as I say, there's two issues there which, to me, as a planner, I would look at that and think, well, hang on, this needs a bit more scrutiny and information to be able to come up with a conclusion. Because at face value, 1.77 is a clear justification for a house. But that information's not been given proper scrutiny, nor can it be through the LRB process, because this is it wasn't submitted at the first stage. The appointed officer therefore couldn't comment on it. It came in and where they're supposed to just make comments on the comments, but they've introduced new material.
Councillor Blake.
Could that now then be considered that we should not determine this today until that information is available, or the information is validated?
Might determine that this information is invalid. Councillor Crowther.
And that's the reason, Ken, looking at this, I would agree. Ian hasn't said it in those terms, but I think we should defer, adjourn, whatever we want to do until such time as we get that absolutely clarified. That's the only point that's sticking for me. If it was exact same information as per what the case officer took this on board, I'd probably have the same opinion. But because this is being regarded really as new matters, it's new information, and it's absolutely substantial to the determination of this application. I mean, I think we should adjourn, defer, whatever it takes until such time as we get the fullest information on that point.
Yeah, there's two choices. This is their idea of putting in an agricultural justification, which would have been far better if it had come from an independent source rather than the agent's side. I don't know if I should, well, I'm going to say it anyway. I happened to be to drive past this site last Thursday. I was on another mission altogether, nothing to do with the council. I was going past and I thought, oh, I've got the papers, I'd better stop. There were 7 horses and 1 cow on the whole of the property. There's no sheds that they could be hiding in. There are no sheds there. So the agricultural justification, as far as I was concerned, was out the window at that point. But that is information which I don't know if I've said it. So it so happened I was there, and I happened to stop, and I stopped twice actually in the length of the property because it is quite a long property.
Well, just to make it clear, the two options you have are that, well, going back onto page 13, If you are submitting new matters, which again, the process says it should have been submitted at the outset, you should explain in the box below why new material could not have been raised with the appointed officer before that time. Don't forget the appointed officer had requested this information and pre-application advice and it hadn't been submitted. Or why you consider that, e.g. exceptional circumstances, it should now be considered in your review. So they didn't submit it when they should have done, and they've submitted it now at the last stage. So your two options are, you can either say, well, this is such new material that we think that it requires a completely fresh application and being looked at properly. Therefore, you would uphold the officer's original decision on the basis of the information that the officer had at that time, without prejudice to a further application coming in where a more detailed analysis of this could be done. Or you could do it through the LRB process, which would take you into further procedures. So you'd be looking for written submissions from the applicant to give more detail on this, and for the view of the appointed officer to give a further comment on what comes in. That's going to obviously get quite protracted. So it's entirely up to yourselves. You have these two options. I would suggest that you're either upholding on the basis of the original information that the appointed officer made the correct decision on the basis of the information that they had at that time. Further information can be submitted with a fresh application, or you go to further procedures and try and, through the LRB, tackle that matter.
Members? Councillor Gilroy?
Well, I think we deal with what we've got in front of us. And I think we go to page 13, where there's an opportunity to put in new matters. It isn't there. They've introduced a new matter, which the appointed officer has had no chance to comment on. So therefore, we are dealing with it ourselves. And that's not really the thing we're here to do. We're here to see whether the appointed officer made the right decision or not. And I think this should be, we shouldn't pay any cognizance to this. I think it should be taken out. If it is important to the applicant, then they can presumably reapply with this as part of the proper application, and that would be the appropriate way forward as far as I'm concerned.
Yeah, the appointed officer made his decision on
what he had in front of him.
What he had in front of him, which
Absolutely,
is not this.
which was not this.
We're supposed to be reviewing. Ian?
So that would be my views.
Yeah, without prejudging it with David's explanation, if that was, if we did decide to not to uphold this, and it could be written in such a way that it's such information that it needs a fresh application, I'd be happy to proceed on that basis.
Yeah. Ian, Councillor Crothers?
Thanks, Chairman. I still say this is in front of us. We see it, it's here. I mean, if I had the clarity on how much weight we should give to that, I would be happy enough to determine the day in whichever manner and leave it at that. It just, all I need is the clarity. Should we give weight to that or no? It is in front of us. We can say it's new matters that they could have addressed. They've actually put it to us for information. We have got it in front of us, visible. But I just need the clarification in regards to how much weight should I give to that, because I'm not professionally qualified in to look at this and say, well, that means X, Y, and Z, and that's how much weight I should give to it. And I just need the clarity. David's a wee bit on the edge with that. He'd like to. I think it's what he's saying. He'd need a bit more time to get absolute clarity on that himself, or at least time to digest and consider it with others. I'll give the appointed officer another chance. I mean, I'd be happy enough just to move on for further procedures. Let them both come back. Let the appointed officer look at this, take full consideration of what's there, and I don't really see what's relevant for the actual applicant to come back with anything. Because it's there, it's in front of us. I wouldn't want them to introduce any further new matters, unless that's a point of procedure that they have. Again, it's absolutely a must, but I'd be happy enough to take further advice through further procedures from the appointed officer, and I think we determine it in that manner.
If this had been brought under page 13, I think it is, the appointed officer would have had a sight of this and he would have been able to comment on it. As we are, he hasn't seen this. He didn't get the opportunity before the papers were written. Is that right?
That's correct. I mean, basically, it's all front-loaded in the process. You're supposed to submit everything that you wish to be considered. During that process, there obviously is a report, which you've got in here, which is starts on page 15, which was what the case officer had to go on. The key emphasis which comes through to me that was submitted with it was the need to comply with the Animal Welfare Act. What has happened is that they've gone away and come up with this extra information. It's not been subject to any officer scrutiny at all because the process doesn't allow that. Had it been submitted at the outset, then where it should have been in box 9 on page 13, then that would have allowed Robert Duncan as the appointed officer to actually have a look at this and make comments on it and give you some advice as to whether or not this was considered to be robust. The difficulty that you've got is that this is coming at the last possible moment. There is no opportunity for the appointed officer or the case officer to make any comments on it. As a planning professional looking at this, my advice is that I'm uncomfortable about two elements of it, and I would query how much weight you should actually give to this unless it's been through proper scrutiny. But ultimately, I mean, I can tell you what my own opinion is, but it's up to yourselves as the LRB to come to a conclusion as to whether you want to uphold on the original decision on the basis of information that was before the appointed officer, and given that no new matters were submitted with the LRB submission, or do you want to try and tease it out further, get more clarification of what's there, and run that through the LRB process? That will obviously go to further meetings in due course.
Councillor Crothers.
If David, you just give us his professional opinion at this moment in time. I know you've kind of run past it already. You've went over the fact that there's horses may not be included, but just as best you can, David, and that would make me more comfortable.
I think he said it was personal opinion, not professional. Anyway, we'll hear what he says.
In a professional opinion, I think what has been introduced on page 59 is totally new material. It could materially affect the consideration of the application, and therefore my own view is that what you should be doing is actually upholding the original decision on the basis that it was made at that time on that information without prejudice to a further application coming forward, and that would allow proper scrutiny of that information, because otherwise you're not getting the full proper information, I don't think, before you as an LRB. Even through further procedures, it won't have been subject to public consultation. So there may be members of the public who would have something to comment on this, but they'll have never seen that information either. So for that reason, my own professional opinion is that it would be cleaner to simply say that on the basis of the information that the appointed officer had before them at that time, they made the correct decision. But that's obviously without prejudice to a further application with more details.
I think we'll leave that to debate at the end, if we could, if that's okay, and we'll just go through the other sections, then we'll come back to the debate. Section 5, planning application form, dated the 25th of June 2013, plans and associated documents. That goes from 63 to 75. Is that right? Right bit. Nothing. Section 6, decision letter from the Dumfries and Galloway Council dated 27 September 2013. See the word contrived again. Section part 2. Anything? Okay. Section 7, relevant extracts from Dumfries and Galloway structure plan and statutory local plan. Anything in there? No, I'm just waiting to see if anybody's got anything else to say. Okay, and the last bit's photos of application site and the locality, which we've seen the slides of. This thing we've got to decide, I think, is have we enough information to determine this today? Councillor Crothers?
I think we have, Chair.
Okay. Anybody any otherwise minded? Okay, well. Thoughts, people? Councillor Crothers?
I mean, on the back of, I would say, the professional advice that was given by David, I think that we shouldn't use, it's there, it's within the committee report, the observations, the applicant's reply, that we shouldn't, this is new material, it's new evidence that has been introduced. We shouldn't accept this today, but on the basis we should uphold the original decision, but taking into regard at the same time that if this information had been in the original application, it may, and I must emphasise may, there may have been a different outcome in the decision.
Any other members? Councillor McCautry?
Yeah, I mean, I agree that we should uphold the decision. The fact of the matter is we can't make any qualification that the decision may have been different, because we don't know what response the planners might have made to that information that we've got in front of us.
The only reason I worded that was so it's absolutely clear that there might have been a different decision, and I worded that in the back of what David had actually said. So it may not. You can put it just so there's a clear emphasis, because Ian said earlier that if we were using that information, it probably would be a different decision.
I don't think you need to qualify a decision. I think we're here to make a decision based on the information before us. And if we make that decision that we refuse it, end off, that's then up to the applicant to decide what they want to do, submit a new application. So I don't think we should put a qualification in.
Councillor Blake?
Yeah, I think David's actually gave the correct advice without prejudice to any further application that may be made. That would cover that.
Okay, I think we're agreed on that. Paula?
The committee has determined to uphold the officer's recommendation and refuse the planning permission for the reasons as set out in the officer's report, as far as I knew. All planning decisions are without prejudice to further planning applications, really. You have to consider each one on its own merits and information put before you.
Councillor Blake?
I think probably where we're getting from there is just the fact that I think we should maybe explain the reasons why that this information wasn't submitted.
And what I was really trying to tease out there is you have determined to uphold the officer's decision to refuse planning permission, and the exact reasons for that, and the reasons, as far as I understand your debate, are that you agree with the officer's conclusions that the policy objectives are not being shown to be met. Is that correct?
That wasn't what I said. I would agree in part, but the other part was we would not accept new matters. The new matters that were introduced, and that's the point I was trying to get to. That's the only reason I used the word may.
The decision notice will actually note that the LRB chose not to accept that new evidence given on page 59. That leaves things open for them to resubmit that with a further application, for which there would be no new fee within a year of the original refusal.
From the date of refusal, not the date of application?
No, it goes on the decision.
And that's today?
No, that's a year from, just to be clear.
September it was.
Yes, because you're reviewing the decision that was made, but the actual decision was the 27th of September. So,
okay. Yeah. Okay, thank you very much, members. I have no further business. Thank you for your attention and attendance.